We're live.
Okay. We should have at least like a couple of people over there.
We're just giving them the red line copy you sent us.
Yeah, so we use the red line that Teresa made and bolded the red stuff. So you can see it.
Thank you.
Hold up the other. Oh, I guess. I got you.
What's the red line version?
We don't have the red line. So the red line board that we open up for everyone to have their own file.
I'll share.
Yeah.
So then what do you think is the next step? Like,
Well, actually, because I don't think, I don't know who will bring the shot.
Okay.
We are waiting on Gina Riccovato. She will be here. She's just on her way. Should be.
In a couple of minutes anyways.
What, yeah, just me,
So-
you know.
How usually the loss of that is constructible EVs, the money ones that they're kind of the side of the house.
Gradients.
Gradients.
That's curious, because I mean, I really think that.
We'll fix it. You lived in Yes, okay, yes, okay. We got it, yes.
And that general, regardless of.
What's up? I mean, that's what we did. That piece of tire that we had, it was just process.
Yes,
Rotated it all the way around. We had those services. So, but I'm like, you guys have to come on. Do you make it right? Like all the doors, that also.
When I showed the basic structure, and, give them the.
Is there allowed?
Just show them my slides, and you can always figure out.
Is this something that needs to Let's show you what's happening.
If you memorize that, or you can understand.
That's what I remember. I don't go on camera unless I'm getting paid. That's my screen actor's good.
Because they will post.
Yeah, like, you know, like, I'm very busy. I'm very busy for you. But not quite. No, it's just empty space in the middle, and then you've got the gate, and then, yeah, and that's how it is.
Are we smiling?
She's parked, she's kind of coming. What's that?
Just let me know when.
Yeah, well, she'll show up in the
Yeah, just in case.
Actually,
Well, I didn't hear it. I'm on that team. Yeah, you don't want to.
All right, we're ready to get started here.
Good afternoon. It's a little after 1:10. For the record, it's November 7, 2025's ongoing union negotiations with Pasco Hernando State College and the United Faculty of Florida. Dr. Hall, since regard cannot be here today, his daughter is having a procedure. But he will obviously recording and we'll debrief him afterwards. Dr. Pilley is back.
I do apologize. I might have to walk out. I can't sit for long, so I'm all patched up.
We had brought him up to speed with the last negotiation session, so I think he's knowledgeable. Where we left off last time was obviously we made a proposal and Dr. Hall went through his philosophy behind that. And we haven't met since then, so we assume you all have been busy reviewing that. And so I'm going to turn it over to you all so you can respond or tell us how you want to proceed.
All right. Well, first off, I just want to say we're really glad to see you, Dr. Pilley. Glad you're okay. And we really welcome your input and help with this process. Today, our goal is to work with the administration to update the collective bargaining agreement in order to protect and preserve basic faculty rights while also meeting the college's evolving operational needs. We appreciate the hard work that the administration has put into this process, and we have taken the last 2 weeks to carefully study the administration's proposal, talk to folks, and get feedback. We have found many areas of agreement and have some areas where we would like clarification. We want PHSC to be the best college it can be. And we want our excellent faculty to feel workplace satisfaction and security going forward. We look forward to a productive day of negotiation and agreement. All right, so what we have planned for today is we printed out the red line document that Teresa made of the the proposal and the current CBA. So that's here. And some people are sharing, but everybody's got some access to a copy. And what we would like to do is talk about areas of agreement, areas of possible revision, and also areas where we'd like some clarification before moving forward. So I guess we'll start with Article 1. Our plan was to go through in sequence. So starting with Article 1. So Article 1 is the recognition clause, and this is saying that the Board of Trustees recognizes UFF, United Faculty of Florida, as the sole and exclusive bargaining agent. Could someone from the administration talk about why that was crossed out?
It's already just restates the current state of the law, so it's not necessary to have in the contract. Just the short of it.
Okay. If something's not in the contract, though, it's harder to enforce. Is that the intention?
Well, I disagree with that statement. I don't know what. Law is the law. We have to recognize the union as the exclusive bargaining representative of faculty members, which we're doing now. If we don't do that, then you have the right to follow fair labor practice.
Then what is the reasoning for not having it in the contract?
Just as I said, it's not required to be in the contract. I'll flip it around. What's the need to have it in the contract?
Reassurance. The faculty would like to see it in the contract because it gives us reassurance that this is above board and you guys understand that we are the representation of the faculty in these matters.
Us being here should give you that assurance.
It's not sufficient for the faculty. They want a stipulated assurance in the document. If it is the law, then it shouldn't be a big problem to keep it in.
Well, as Dr. Hall explained last time, his philosophy is if it doesn't need to be, because it's already a state of law, we don't want to have a contract that's 200 pages when it need only be 20 pages.
There's not
lots
very
of
many
stuff
items.
that's the law, and we can't, I mean, you can walk in the law library and you'll see volume after volume of what the law is. You can't possibly cover it all in here, and so we don't think it's necessary.
Well, the administration isn't open to printing the document, so I don't see how more words are it's gonna be an electronic document. I don't see the rationale here. Okay. For the administration's Article 1, those were definitions. Thank you for putting those in. I think that really helps. It's very clear to everyone, all of these terms, and I think that helps everyone to we're on the same page about what certain terms mean. For a supplemental course, it says nursing clinical, should that be health programs or something more general?
Which one was
Third
it?
line on the second.
Supplemental course, any given semester to include no more than 6 ECH or 225 for nursing clinical?
It should be clinical,
Okay.
so,
Yeah.
yes,
For clinical, okay.
yes, you are correct, Cash.
And then for work contact hours, we have a clock hour is 60 minutes, an office hour is 60 minutes, but I believe a contact hour should be 50 minutes. Is that true for like lectures or college credit courses? A contact hour is 50. We have 75 minutes twice a week.
No, it's 60. It's how they reported to the state. I
Okay,
can double check again.
yeah,
The only is the lab and the clinical. That's how it's reported in MIS to the state. So we
Okay.
just stuck with the state standard.
sure, okay, that's fine. But it's good to have the clarification there then. All right, Article 2, general provisions. So I think we're generally agreeable for the definitions then, so that's something that's mutual. For general provisions, supremacy and severability, again, why was supremacy and severability removed?
I don't think it's necessary to be in the contract.
Okay. And non-discrimination.
Same thing, it's already the state of the law, so I don't think it's necessary to be in the contract.
So it's true that non-discrimination is part of federal law, but when we have the non-discrimination in our contract, that means that if a faculty member feels that they have been discriminated against, they can file a grievance, which is different than a federal lawsuit. And we believe that would actually be in everyone's best interest. It would be resolved sooner usually. Would the administration be open to putting that back in or a form of non-discrimination back in?
No, we're not open to it. We think that the statutory process is a better process to resolve any disputes over discrimination.
I mean, with this third refusal in terms of Article 1, recognition, supremacy and severability, and now non-discrimination, you start to wonder what is the point of, I mean, if you could kind of speak to that, what would be the point of having a collectively bargained document, if these things are removed, it's just so blatant, I have to say it out loud, because we're thinking it.
The administration's view, it's not bargaining because it's just what the state of the law is. So it's not as if we came in and over the last 5 years decided what's discrimination, what's not from a legal standpoint. We just adopted and put in what was already the state of the law.
But to
So it's not
Caitlin's
necessary to
point,
have it.
there's a different process, so the grievance process is different and would save all parties more time, because you have, from what I'm not,
Well, it doesn't save all of the time because of what we have in there now, which I'll point out has never been used since y'all have been here. So again, this is what we're wondering on our side is why it's a big deal. We're trying to negotiate the things that should be important, which are the wages and benefits. And you all are getting hung up on language in here that says, well, you want to be able to grieve something where we have, you can go to the EEOC, you can go to the local agency, you can go to the Florida Commission on Human Rights. Right now, what we have in there under the expired contract is the option. You can do that, or you can file a grievance, but not both. Which we went back and forth, and you all remember that. No one's ever used that. And from our perspective, the current administration doesn't think that's in anybody's best interest to have it go to a grievance, which ends up with a third-party arbitrator with not necessarily any expertise in anything having to do with discrimination, as opposed to going to the EEOC or the FCHR and the courts, which have experience in it. So
I think
we're willing to discuss it, and
Yeah.
maybe if you have a proposal that you'll come in there, come to us and say, well, we want to change the law a little bit, and we want to put it in there, and we want to preclude anybody from going to the EEOC or the FCHR instead. Let's go and have a grievance procedure only on that. I'm just speaking for myself. That would be something that maybe we can take back and have to discuss. That's, kind of a supplement to the existing state of law. But last time when we went through this article provision, you were pretty firm that there was no interest on the union side in doing that. I
I
assume
think
there's
this
still
goes back to what Gina said about security. Imagine you're someone in these protected classes and you see that our administration crosses out that they will not discriminate. We've never used it. It hasn't happened at this college. But there's a lot of emotions behind this. There's a lot of feelings behind this, where people want to feel secure. They want to feel like they can go to work and be who they are and not worry about whatever characteristic of them that someone might not like could harm them. If no one's ever used it, then just leave it in there. I don't think there's any harm in having more words to our contract. They don't cost money, but they're going to give security to people. These words give people a feeling of safety.
having it taken out shouldn't take any of that security away. That's you all deliberately spinning that narrative for yourselves, because no one on this side is saying we're taking any rights away. And I'll repeat it again, Dr. Hall said it last time. The view is if it's not necessary, it's already covered by law, it doesn't need to be in the contract. That's not the same as saying we're taking something away from you. Anybody who feels like they've been subject to discrimination still has every right to go file with administrative agencies that are experts in this, and that has happened.
But do you see how it makes faculty feel?
You know, I can't change your perception. If you all want to believe that we're doing something we're not doing, what do you want me to tell you? We're not taking away your rights. We've been forceful with that. There's a different philosophy, and do we need to have a contract that's full of stuff that's already written in law that we can't change, we can't negotiate it away if we wanted to, and no one's suggesting we do. We think there is a value to keeping the contract dedicated to the wages, hours, and provisions that we are negotiating. We do sit here and spend should be spending most of our time, and that's the wages, the benefits, those sort of things.
Speaking of wages, does the administration have an Article 10
We
with
have not-
numbers? No, okay.
we haven't crunched the numbers. I assume that's what you're asking
Yeah.
for.
all the TDAs?
Yes, I think we're working on it, right now. We're trying to figure out I know the labs. There's
Okay.
a 101 that's starting out a little tricky, trying to figure out how many courses are labs and, how much, because every, like, health scientists have different hours and then, ANS have different hours, so I think it's a little, but we're getting there.
Okay, that's great to hear.
Yeah.
Thank you. Multipliers, yeah, and both. Yeah. So that's the multipliers and raises, or both of those you're working on? Okay,
And I think our position hasn't changed. That's why we gave kind of that range last time. And we still are in that same range. We just have to figure out which part of that goes to the multipliers and
all right, we can move on to Article 3. We were mostly in agreement for Article 3. The dues deduction, we understand that, that was a change in the law.
This was already removed from the last one, I think. It was not in the last.
Yeah, by the time it was ratified, yeah. So, so that's fine, and we understand, simplifying the public records law, that's fine. And management rights we're generally agreeable on as well. If the administration could speak about just the differences between the red line and the 4.1, 4.2, and 4.3. It's a little hard to parse out. I don't know who worked on it.
Just tried to make it a little more succinct.
Okay,
It
yeah.
just was too wordy, so just to make sure that it's just,
Yeah, it seemed like it contained the same information.
it's the
but
same
just
information, but it's just
more concise.
concise.
And Article 5, grievance procedure. We were generally okay with that as well. The addition in E4 is pretty standard, so we were fine with that. All right, for Article 6, a lot of faculty had concerns about the removal of the 45 days prior notice. So these were this is for a RIF, not termination. So it seems that the administration would probably have some level of advance notice, maybe not 45. Was there a reason for that?
well, I'll speak to it. I think the rationale, what we're thinking is that by very nature, it's difficult to predict when you're going to have a RIF, and if you have it. Fortunately, I don't think we've had to have those, but whether or not you'd have sufficient time, so we didn't want to put something in stone in the contract without knowing what the circumstances would be.
Would the administration agree to 30 days, potentially?
If you all are making that proposal, certainly we will consider it.
Okay. And could you speak to the salary and benefits not being offered to a laid off employee? So originally the CBA said the employee released from employment shall receive full salary and benefits until the established ending date of his or her contract. Could we talk about that?
You can propose it. I think we're probably more firm on that. We'd have to discuss it amongst ourselves. But
Okay,
by the nature of the layoff, if you end up having a layoff, then you're no longer employed, and we're not likely to be unable to pay you, essentially.
Well, generally for faculty, they're in the middle of teaching, they're gonna finish their teaching.
Right. I mean, you're gonna, so it's not likely to happen, and there are procedures if you have to go through and try and terminate in the middle of the contract. So it's one of those things where it's probably already in the contract, in the law, but if there is some scenario that it could come up where you would be laid off in mid-contract and we have to go through that process, we would go through the process, we wouldn't want to be constrained by union contract, because by its very nature, that means there's something obviously going on from a financial standpoint or whatnot. It's difficult to predict, but in this area, it's one of those where, knock on wood, it hardly ever gets used.
We thought faculty evaluations had a lot of improvements. So we were pleased by the every 3 years for the observations, and then every year for the annual evaluation, and then every 3 years the classroom observation. I think that will relieve a lot of workload for the deans, and I think that makes sense for faculty who are continuing contracts. So we were pleased to see that. We also like the prior notice to formal classroom observations, the union representative, and the timeline, I think, is really helpful to have that in there, to know,
just
kind
makes
of have an
life easy
idea, like,
for
when is this
everybody.
happening? Yeah, definitely.
So everybody's on the same line, everybody knows every year. There's no ambiguity when it comes to.
That's great.
And developing the PIP and having it very clear. So this
Yes.
is the process.
Yes.
This is what we expect. Okay, it's very nice to have that clarity.
And I think the exceeds, meets, needs improvement, and so on, I think that more specific scale is also helpful for faculty
Yes.
and administrators alike. So I think that's an improvement, and thank you for your work on that. Would the administration be open to having the list of criteria in the, I don't know, I can't even think what's in our evaluation. Like the rubric, in addition to the criteria, the list of factors that the faculty member will be evaluated on?
Sure, we can
Okay.
work on that.
Okay,
Down the bottom for PR.
oh, and PR, is that performance review?
Yes.
Okay, I don't know if it was defined, if it was defined, I
Sorry.
didn't see it, yeah,
PR is performance review.
okay, thanks. Does the administration have any questions for us? For Article 8, we'd like to hear some more description, I guess, some clarification on the 10 hours that are for professional development, instructional programmatic applications, and participation in campus or college activities. One thing I know I was curious about is, where does preparing and grading come in here? Is that beyond the 35? That's included in the 10? Okay, all right, that makes sense. That was the main question I had. I do know also, we heard the goal of a 10%, 8 to 10% raise. Was that equated to the 5 hours? How is that aligned?
I think what Dr. Hall was trying to convey last time, the 3% was what we're doing for the college generally, and then the rest of it above that was the trade-off was requesting to increase the hours to 35.
Okay.
That was
I
part of the
know a lot of
rationale.
faculty were hung up on 5 hours additional is 16% increase in workload versus an 8 to 10% increase in pay.
Right, keep in mind that we're also agreeing to other things, including the multiplier stuff, so I don't know that the thinking on this side was kind of that mathematical, if you will. It was sort of, here's what we can afford to do, and we think is reasonable in light of the trade-offs that we're asking for.
And then it seems that the preference for full-time faculty in course load assignments was removed from overloads and summer assignments.
I just wanted
No,
to.
that was not the intention. The intention was
Oh.
to make sure it was just for full-time faculty as opposed, because this had everybody else, the professor and the the adjuncts. That's not the goal of the CBA. The
Oh.
CBA is about faculty, so.
Okay. Would the administration be open to a statement that full-time faculty have preference for summer and overload over
I think There
others?
is somewhere.
Oh, there is?
Yeah.
Scheduling
It's at the
solicitor.
end of that
Yeah.
paragraph. It's new language.
And
Just
And four seconds?
responsible for
ensuring
all faculty members receive full instruction, but we're talking about the overload.
for the supplemental pay and summer pay.
Well, I can look into that. I have to be.
Okay, okay. Yeah.
I think the language on the overload is in section 8.6A, which discusses that college will give reasonable good faith consideration to requests for faculty members wishing to work overload assignments. That's what you're
I
referencing.
think that's where it is.
Okay, where is that? Which part of the
8.6A.
faculty overload? Good faith considerations. Okay. Okay,
So there's a change in terminology. We're
To
using
priority.
Yeah, supplemental and then overload. So till 21 is supplemental.
okay,
Okay.
Anything over 21 would be considered overload. And that would need permission.
okay. But the good faith
Yeah.
consideration
Yeah.
is the same as preference?
Yes.
Okay.
Could we get clearer language there? Maybe good faith and preference, or, priority and preference? Something a little stronger than that?
No. Yeah, just so everyone understands, they've changed the terminology and the definitions. So from 15 to, so 0 to 15 is your load, course load. 15 to 21 is supplemental. 21 and above is overload.
It would be 16 to 21 supplemental, because.
Yeah, 16
Did I
to
say
21.
15? I meant to say
16 to 21.
16 to 21 is called supplemental pay. And,
And also, it came to my attention that some faculty have been teaching 16 credits in the past, and not paid for that 16. That will be considered supplemental,
okay,
automatic. It's not.
that's great.
Yeah.
That's great.
Okay, we were wondering how that was.
Yeah.
Yeah, so no, anything that the faculty is teaching will get paid for. This whole not paid is not.
Excellent, excellent. And then 8.8 adjunct summer instructional assignments, is there another part that's on our summer load? Was our max we can teach in the summer, it's 9, I believe, is that in the contract?
I didn't see it.
Okay, I don't think it was in the contract,
It was not in the contract.
okay,
And summer is different, so, we're only talking fall and summer is going to be overload, period, so.
There was a section.
Yeah, it would
that
be-
was
it would be
addressed for-
supplemental, right?
Some,
Overload?
No, it'll be overload,
Why is it considered overload?
because the contract is for fall and spring.
Okay,
If
So-
we were doing 10-month and then when we were going into summer, then we can call it supplemental, but since we're only doing 9-month and we're going
Okay.
fall and spring, then summer will become.
So faculty are still able to teach 9 credits in the summer, and do full-time faculty receive priority for summer overloads?
I'm trying to find that assignment.
That language definitely
Yeah,
is-
we'll just leave that back in there.
Wasn't there something on summer?
Yeah, it's 8.8. All right, Article 9 is compensation, so we'd be waiting for a formal proposal from the administration to do that. Is there a timeline for the compensation proposal?
Absolutely, yes. Yes, within the next week.
Next
You
week,
will
okay.
receive the full proposal.
Can I ask, Alma, if you
Yeah.
have any feedback or concern with the renaming of these as instructor, assistant professor, associate professor?
Yeah, I wanted to see the numbers, how that would play out. It seems fine, but I think we'd have to actually do the number crunching to see what it would look like and have some kind of better idea of how that might play out for faculty individually. At this point, I don't think there was really,
And just as a clarification, this is when they're the way that they will be placed as they're being hired new.
okay.
So that's not really changing overall. I just want to clarify that if there were any questions that
Okay,
I can
yeah.
answer that.
Then, if a current faculty, if they look at the CBA and they should be making more money after they got, like, if this change would result in a bigger salary for them now, can they apply to have that salary adjustment?
So I can look into it, but they truly were like,
Just, yeah. Okay,
so I don't anticipate you're gonna see that.
okay, that's good to know.
It's just change of terminology, it's just making it easy. It's too complicated the way. It's easy for somebody coming in there, know
Yeah.
where they stand, how much they're gonna make versus faculty level 1, and then their associate professor, and then when somebody gets a promotion, there's something that goes along with it, so.
And then I don't remember this, like, if you're a current faculty member and as you earn an additional degree, or as you gain more years of experience here at PHSC and you go from associate professor to professor, is that associated with an increase in pay once you're an employee already?
If it's less than the minimum, absolutely.
Okay,
If you're already within the range, you would get the supplement that everyone's entitled to for the additional degree, the earned degree supplement, and then you would be placed at that level. So any changes to that level, that range, you would get. But if you're below, you would automatically get the minimum for that range, absolutely.
so if you're below the minimum for professor and you're an associate professor and you meet the requirements for professor, when you apply to have a rank change, if there would be a pay increase, you would get a pay increase. Okay.
I think, yeah, in the end, to get enough feedback from our faculty, because we're still kind of trying to figure it out, the more we can get that clarified and then be able to communicate so they understand, so we can get feedback.
Absolutely.
So it's not feeling muddy.
Right.
All right, Article 10. Right, that we're at. For the release time for the department chairs and program directors, would this result in less release time for any of the program directors or department chairs?
Can you clarify?
Where is that?
Right here, 9.3. I think some of the program directors, I might be wrong, would get less based on the number of full-time faculty.
So there is one program in particular, I believe, that would get less time just because it is one campus, one small number of faculty, small number of students, and no accreditation.
Okay,
So, yes.
but
that
the other ones would either stay the same or increase?
stay the same or increase, because
Okay.
six is the number that we use now for program directors, so at least 6 and then above. So,
Okay.
Yes.
How many department chairs and program directors with no accreditation response? Oh, okay, 6, 9. Okay, never mind. All right. So could the administration talk about the changes to continuing contract? The whole portfolio was deleted. And then now in our CBA, it says that the college may hire faculty that are not eligible for continuing contract.
It was already there in board rule, I just put it out there.
Okay. Is that something the administration is planning on starting? I don't think I know any full-time faculty right now that are not on the track for continuing contract.
I mean, it's just there if we need, just in case, like, if we come across, there are some areas that we might have to get some on annual because they just don't want continuing, so we just put it out there.
So there are faculty
not-
that don't want continuing contract?
There are some, yeah. And a lot of colleges are going, but it doesn't affect anybody who's already on continuing contract track. It does not touch them, you know. This is just in case if we need to bring in someone on annual contract, and it's already in board rules, so.
And I can share an example, and it's like, I mean, I have had in the past, 1, maybe 2 faculty that, you know, were moving towards continuing contract, and they asked, do I have to do this? It's like they really did not want to go through the portfolio, and they were satisfied being an annual faculty member, but I had no choice but to say, yes, you have to pursue the continuing contract role. So there are occasionally people that do not want to pursue that, so.
And some colleges are finding that you can look around the state, they're doing that as well, so it's just.
So if you have faculty that are retiring or they move out of state, so you have, you know, a needed line in and out of physiology, math, whatever, those are not gonna be shifted to be, you know, a line that is available for continuing contract? Or kind of, it was typically, you know, so we know we need this many faculty in
Right.
these areas.
Right.
But to just randomly say, well, we're just gonna go ahead and set that as a not a, you know, an option for these new people we're hiring to what would be typically how you're gonna round out your faculty staffing to make sure that you can offer the classes, you know, those aren't going away. You know, in my area in A and P, it's only gonna get more, you know, difficult to get people. So
Right.
to then,
And
if that moved to, okay, well, now these new people, they aren't going to, first of all, you would wanna offer that, I don't think, to it already difficult to find instructors. To say, well, no, you're not gonna be a continuing contract line, you're gonna be a year-to-year contract line. I don't really understand the rationale for that, if that is what is being stated.
So I know that for example, maybe some workforce programs where you may be implementing something that's based on demand. That might be an example of where you might have something where you're saying that really, it's a time and, you know, it's based on demand, so you don't want to create an expectation of continuing contract from that. You don't know what that next demand is gonna be. So I don't know if that's a good example for you.
yeah, I mean, this is already in board role, so this has been at PHIC, this is not something that's new.
Can the administration commit to hiring faculty in certain positions as continuing contract?
Continuing contract absolutely is on, it's not like we're taking away continuing contract, no, that's not the case, but I think there needs to be some kind of flexibility where we can bring in annual contract faculty as well.
So I know there's a number of hires, a number of new faculty positions open. There's math, there's speech, there's political science.
Political science.
Yeah. Will those positions that are being hired right now be eligible for continuing contract?
Yeah, I think so. Yeah, we have not made anything that is yet annual contract.
Okay. Could we get a commitment that certain fields will always be continuing contract? I can understand, the workforce or make a limit to temporary contracts. This is something that's near and dear to our hearts, is the concept of having continuing contract.
You all can propose it.
You can propose it and let's
Okay.
look at it.
All right. So for 10, or which became 11 benefits, from what I could tell, you just made it more succinct again. It's basically all the same list of everything. This was pretty repetitive in Article 10, so that makes sense. Okay. And I believe the full-time faculty who have not submitted a resignation by May 31st shall be responsible for all summer premiums that would have otherwise been covered by the college. Can you speak to that?
Yeah, so, the employees should be able to determine or notify that they will be teaching in the fall. There are some expectations they will teach in the fall. If they don't notify us, and they're gonna notify us last minute that I'm not coming back, let's say, 2 weeks before school starts, that would be a situation in which we're saying, wait a minute, we paid for your premiums all summer. If you don't notify us with enough time for us to be able to go in and find a suitable replacement, that's the situation in which we're talking about, just providing ample notice to administration that there is not an intent to return.
Well, I think we have been over this, but if you have an 162-day contract, it's in a year, 162 days. As of graduation in May, you've completed all of your requirements for that contract. The administration has committed to providing premiums for the contract for the year. I think that is only fair and right and just for the administration to continue to pay your premiums for your healthcare that you've earned.
Is there no responsibility on the faculty to notify administration that they're not returning?
Absolutely, but why doesn't the administration just always pay for them? It's in the budget for that position. So I could tell you, I'm not coming back, it's April, I've got a job, I'm not coming back in August, then the administration could continue to pay my premium.
That's what we are saying. It's like, you give us notice, we'll continue to pay it. What we're trying to do is avoid these situations. It's when you don't provide notice.
What if you're not returning and you do provide notice?
Well, then it's paid.
Oh, I didn't understand that.
We needed to make that clear there,
I
yeah.
understand that.
Yeah.
So
no.
full-time
Oh,
faculty
okay.
who do submit a resignation by May 31st will receive the full,
If you want to do it
term
in
of their
the
summer.
reverse.
okay, so we just, okay. That's
Okay,
Okay. Yeah, I just thought that the history was such that
Yeah.
if people did not report it because they were not going to. get
That's what we're
their
trying to, that's exactly what we're trying to
So that's why
avoid.
they
good.
didn't report it.
It's
Yes,
clear.
that's
that's
exactly
much
what we're
better, and
trying to
that's
avoid.
better for everyone.
Yeah.
Yeah.
Because it gets dicey trying to fill classes at the last minute. So
Absolutely.
I
Okay.
think the conversation was, we'll cover, just let us know, no
Got
harm to the
So
faculty.
we may want to just.
Okay,
it.
thank
Yeah,
you.
just- Okay,
Absolutely.
all right. Well, it's 1:51, which is a 50-minute class period. I'm ready for a break. So can we take a 25-minute caucus and come back and continue through this?
Sure.
Okay,
Thank
Okay,
you.
great.
thank you.
Stopping point is Article 12.
Yeah.
You all can stay here, we'll go wherever before.
Okay. So back at, what time are we back?
No, I got it.
2:25?
Oh, okay, go ahead.
About a half hour.
That's